The landlord did fail to install or replace smoke detectors, failed to proper snow removal, failed to replace a broken air conditioner, in retaliatory termination, engage in stalking. Where in the lease does it say that he's responsible for snow removal agreement? You signed your lease agreement. I didn't.
Anything I complain about, he threatens me. He threatened to kick my ass and threatened me via text for no reason. And he's out for blood, by the way. By the way,
I'm only going to tell you one more time.
Today we are in Cadillac, Michigan with Judge Wiggins. He's already had a rough day and this defendant is pushing his buttons. I can't remember the last time I really saw a real judge bang a real gavel. This case is a landlord-tenant case. The fella in green on top is the plaintiff, and he sued the two blokes at the bottom, the quiet son and his loud, obnoxious father, for eviction. They had a good relationship for a while, but things changed and the landlord wants his place. I don't blame him. It sounds very much like the defendant is that neighbor, that tenant, that guy, who just can't get along with anybody. So rather than lose his house, the defendant launches a counterattack based on some pretty weak claims that a jury may soon get the chance to laugh right out of court. Let's roll, nerds.
Okay, we are back here for, I think, the third time, if I remember correctly. We had set today's date to determine if there's a tribal interest to take to, a tribal issue to take to a jury, which tentatively is scheduled for May 16th. Defendant had filed a counterclaim against the landlord, in this case, Mr. Story. This case begins with a summons and complaint for unpaid rent and possession. So where we left this last time we were here is we were going to hold today's hearing, as I said, to determine if there's a tribal issue. I know, Mr. Story, you had indicated that you thought you would have an attorney here today. When we left last time we were here, do you plan to hire an attorney or continue to represent yourself?
Am I allowed, Your Honor, to make that decision after today? It's not been, in my experience with landlord-tenant, I haven't been up against something like this. I think at this point, I'm trying very hard to get this over with. I don't find that his counterclaim holds water. I don't think it's really fair that he doesn't pay rent for 3 months and then all of a sudden I'm on the stand and I have to drive over 100 miles to come up here and try to defend myself against something that has no evidence, no dates, no pictures. We've been provided nothing. All information and communication with my manager and everything else has been shut down. I think it's a mockery and an opportunity for him to stay longer and continue to waste my time. I have 3 jobs. I'm a full-time dad. My kids are going to be done with school soon. My wife's a school teacher. She doesn't get out till June 18th. And quite honestly, I'm just starting to run out of patience. So if that's what it's going to take to get this done, and please excuse my stress. I have to step out to call a babysitter, and I don't even know who to call because I got here at 2:15.
Yeah.
My kids get off the bus in an hour. It's starting to me to get to where I'm wondering if that's what I need, but I wanted to come up here and see exactly how this is going to pan out. I definitely have some questions for the tenants, and I'd like to see where that goes. But if it's going to continue, I think, yeah, most definitely I'm going to have to bring in an attorney. But I'm not, on record, I'm not deciding that yet.
All right. The only reason I asked is because, as I stated right now, we're tentatively set for a jury trial on May 16th. We've not sent out the jury demands yet. Those will be going out tomorrow, assuming I find that there's an issue to take before the trial, before the jury. You can get an attorney at any time. The question just is, I don't want to waste our time by sending out jury summonses only to have an attorney come in and saying that he or she hasn't had enough time to prepare for a jury trial and be ready. So I'm the only reason I'm asking that is trying to determine where we're going to be at, if we're going to be ready for a jury trial.
Well, Your Honor, I don't think I'm going to need an attorney. After looking at this case, there is no evidence of his claims.
Well,
I
that,
see.
today was one of the issues. They had to come today to present to me to determine whether or not there is an issue to take before
Sure.
the jury. So,
And if there is, then I will be hiring an attorney and coming back with probably 5 times the amount of counterclaims that if you find, that those hold down water,
okay,
right?
well,
So, but I've been cordial in this matter. I don't want to get into that. I'm here to serve an eviction. And, we notified him in March as a courtesy, and that's when all this stuff came up. There's a signed lease that contradicts most of this.
okay, so let's do this then. So I will, as of right now, you're not planning on an attorney. I still have a docket to get through, so let's start taking some proofs. So Joseph and Shane Newmeyer, if you both please raise your right hands. Do you solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth?
I do.
All right. Mr. Story, will you please raise your right hand? You solemnly swear that the testimony you give today will be the truth, the whole truth, and nothing but the truth.
I do.
All right. So I have gone through this case. There was a summons filed on March 27th, 2025, requesting a money judgment and an order of eviction. There was a complaint filed the same day declaring or claiming that $750 was owed in rent along with a $25 late fee. We were here back on, I don't remember the exact first date we were here, but we had adjourned for legal advice. A request for a jury demand was inputted, and the fee was paid for that. And the counterclaim by the Newmeyers against Mr. Story was received and filed. Essentially, the counterclaim states that between the dates of June of 2024 through May of 20, says 24, but I assume that's 25, the landlord did failed to install or replace smoke detectors. As a result, the rental value was reduced by 50%, $375 per month, for a total of $4,500. In paragraph 4, it alleges that in the months of February and March of this year, the landlord failed to proper snow removal. As a result, the rental value was reduced by 50%, $375 per month, for a total of $750. In paragraph number 5, it alleges that in the months of May of 24, the landlord failed to replace a broken air conditioner. The result of the rental value was reduced by 50%, $375 per month, for a total of $375. Then in the second paragraph 5, it gives the authority for abatement of rent. In paragraph 6, it says the landlord did twice engage in retaliatory termination of the tenancy of the Newmeyers in the last 12 months with violation of MCL 600-5720, and that the defendants seek relief in the amount of $4,500 or 6 months worth of rent. In paragraph 7, it alleges that the landlord did in the last 12 months engage in stalking, repeated continuous harassment of the tenants, the Newmeyers, in a willful manner, harassment that caused to experience feelings of intimidation, fear, or even terror in violation of MCL 750.411H and MCL 750.411I. The defendants seek relief in the amount of $4,500 or 6 months of rent. Wherefore, the defendant seeks a judgment for the amount of $14,625 against the plaintiff. So let's start with Joseph Newmeyer. In regards to your allegations regarding the smoke detectors, what can you tell me about that?
I can tell you that we originally moved up here for a job offer from this man. Okay, this man makes them out.
No, the question is, what can you tell me about the smoke detectors?
We have not had working smoke detectors since we moved up here for a job offer 7 years ago.
And what makes them not working?
There are none. I got pictures.
Hold on. All right. And how do you come up with a 50% reduction in rent because of a
For the safety
smoke
issue,
Okay. Do you have anything to value that at 50%?
do I have anything to value it?
Yeah. I mean, are you just pulling the 50% out of the air, or do you have something to say that non-working smoke
It's a
detectors?
serious safety issue.
Let me finish my question. Or do you have something that says that non-working smoke detectors result in a 50% reduction in the rental value?
No, I don't have anything that says that.
Okay. And so for the months of June of last year, July of June of last year, all the way through, again, I think it's a typo, but it should be May of this year, which just started today. You're claiming that you did not have a working smoke detector at all during that time,
In both rooms.
right? And did you notify the landlord of that?
The landlord knew, came and did an inspection. I have documented proof of that with his handyman. And at that day, my son and I were both present for this inspection. I have text proof of him coming for the inspection. At that time, he was planning on selling it. He inspected all of the units. I have photographs before he came and inspected it, and photographs all the way up until even today. Well, I didn't take it today, but I took it like 3 weeks ago. And by the way, he did state, like he does a lot of things, he said that, you know, he cuts me off with, he says he cuts me off with communication. He said that he was gonna have somebody contact me right away to fix this problem. He's denying knowledge of this, okay? Your Honor, he has knowledge of this. Much like the snow thing, I've got proof of this too. He says, right after he received the proof of service I sent him on the 25th, sir, he sent this out right away. If you remember the last hearing, and I know you deal with a lot of people, at that hearing, I realized he had not gotten the counterclaim yet. So right after that counterclaim, on the same day, he sent 3 texts and emails to me, all denying all the stuff that I have proof of, okay, including you know, he said that he wasn't aware of the snow plowing, okay? Well, I've got him right here after, and I have documented pictures.
Mr. Newman, I have to, hold on, both of you. My patients are tested today, and I'm not gonna put up with this stuff. Does everybody understand me? This court will work in the way it's supposed to work. I will ask the questions. When you are asked a question, you'll answer, and not until that point. I am dealing with the smoke detectors at this point. We haven't gotten to anything else.
Okay. Yes, sir.
So what do you have to prove that the smoke detector is not working?
I have pictures and photographs right here.
And it's your claim that they've not been working since you moved in.
Absolutely.
And when did you move in?
I moved in at the end of 2019, like I said, for a job offer. We haven't been leased for 6 years. That's the absolute truth, and I can prove it.
Was this lease that's in front of me, does this not start in June of last year?
Yes, but we've been there we came up,
So-
like I said, which I think is relevant to the case, Your Honor. I know I'm sorry you're patient. I'm not trying to test your patience, okay? I'm just saying. We came up for a job offer. The original offer was $750 for me and him to come up and run the hotel, okay? I'm working on FOIA requests to do this because I think it's relevant to the case. How often is it in a tenancy you don't have a lease for 6 years, okay? We came up there and then the pandemic hit. Okay, after the pandemic hit, we shut down for about 6 weeks. He opened back up. When he opened back up, we started working running the hotel again, okay? I can prove this too. I just got to get the documentation. I haven't got that yet, but you know, I've been trying to cover all this, okay? I have limited resources. Bottom line is that then he tells me, well, I can't really pay you for that, but you can keep a roof over your head for running the hotel, which we did for 12 months. Then eventually we moved to rent.
Mr. Newmeyer, the question is whether you're in default of the lease that you signed back in June of 24. So we're only dealing with that moving forward.
Okay, so am I in default?
I haven't decided that. That's the question I have to determine.
Okay,
So we're only dealing with the lease that you signed in 2024. And in that lease, you signed the lease that stated there were working smoke detectors in the unit.
well, of course, I couldn't say, you know, he did tell me that day, he said that, you know, it's gonna be a while before it fixes these, and anything I complain about, he threatens me. I've got documentation of that too. I mean, I've got actual pictures, like I said, sir, before the inspection.
When was the inspection?
The inspection. 21, so it was April 24th, 2024. I have pictures of April 21. I have many pictures, but I only have a couple on this tablet here because I didn't want to give the court too many, okay? But
Is it your testimony that you've lived in this unit for 7 years?
yes,
This exact unit?
yes,
But does the lease not state that the tenancy starts in June of last year?
yes. but I still lived in the unit, as I said, with the prior agreement where we,
Why did the lease not start? Let me just take a look at something here, make sure I'm right. So the date of the lease is April 19th of 2024, but tenancy doesn't begin until June. Why the couple month delay?
he did that. I don't know why. I just, like I said, it's a very impressive environment. If I don't agree, he'll do what he does,
You'll get your turn. Okay, then moving on to the snow removal for this month, I'm sorry, for February of this month and March of this month.
Yes, sir.
Tell me about that.
I have multiple pictures. It was going smoothly when I was renting the place because I made sure it was plowed, but for some reason, after we got out of that, it wasn't happening. So there's numerous tenants, and I have pictures of other tenants that got stuck as well. They're just afraid to complain because he does what he does. But the bottom line is that I have documented pictures. I had to hire a tow truck to pull my vehicle out. Couldn't drive my son to work. That's how we pay rent, okay? I have documented proof of this. And I'm sorry for my tone, but this has been living hell for me ever since he's had it in for me for the last 12 months.
Where in the lease does it say that he's responsible for snow removal?
Well, it's an apartment complex.
Where in the lease does it say he's
I don't
responsible?
know. I'd
for
have
snow
to
removal?
review that.
Okay,
Bottom line is that are we not entitled to snow removal where we can drive to work? It's an apartment complex.
you are entitled to enforce the contractual obligations of the contract. My review of the contract did not show anything about snow removal.
For the entire apartment complex. So basically, he can just not plow.
I wasn't the one who signed your lease agreement. You signed your lease agreement. I didn't. We can only enforce because the lease also has a clause in it that says there are no oral agreements. Everything is in writing and incorporated into the lease. So if you can point to me in the lease where it says he's responsible for snow removal.
I have to review that.
Then in the month of May of 2024, the broken air conditioners. What do we have about that?
Yes, I have documentation that we installed it ourselves via text. Right here. And I have pictures on this cell phone, but I haven't been able to move them to the other. I wanted to do that as a jury trial.
Did you install a window unit?
Yes, I did.
Okay.
I have pictures I can provide.
Let me ask my questions. Did you purchase that unit?
No, he did it Habitat for Humanity for around $20.
But you installed it?
I had no choice.
Just answer the question, yes
Yes,
or
I
no.
installed it,
Did you
sorry.
install it? He purchased it,
Yes,
you installed it.
yes.
And how long in the month of May were you without an air conditioner?
2 weeks.
When in the month of May?
No, it was June.
Your,
Or no.
your counterclaim says May.
Oh, yeah. Okay, wait a minute. Yeah, that's correct. And it was very hot that time. That's why we had to put it in. And the rooms get hot anyway, but yeah.
My question was, when in May did you have to install a window air unit?
Well, I kind of 2 weeks prior, but when I installed it was, and actually I installed one. And then because it was a 20-hour Habitat for Humanity, it broke and I had to install another one, which I have on these texts. So on May 22nd, after I'd contacted him for 2 weeks, and then I'd sent him another text here, May 17th, 5 days prior to us installing it, we just couldn't wait anymore, 5 days prior. Here's my text. Took us 45 minutes to get the old air conditioner out, jammed in terrible. Had to beat it on the outside with a very large hammer while Shane pulling the inside. I have actual pictures of this, by the way. By the way,
I'm only going to tell you one more time. Answer the questions that are asked. I'm not asking a narrative. I asked when you installed the air conditioners.
May 22nd, 2024, but then another time we had to pull it out and install another one on May 26th.
Okay. And when was he first notified of the air conditioners?
2 weeks prior, but the documentation I have of the last text is May 17th, so 5 days prior.
Okay. And did he purchase both air conditioners?
More than one, more than two, but yes, sir.
And how do you arrive at the value that is worth 50% of the rent for the month?
We had to install
Are you charging for your labor?
charges for my labor, the discomfort.
How much do you pay? How much do you charge for your labor?
Didn't come up with a price for that, Your Honor.
How did you arrive at the 50%?
Just to figure for the discomfort and the fact that we had to put it in. I've got bad knees and we had to install this thing ourselves.
Did you, so you have nothing that says it's worth 50%. That's just the figure you arrived at?
Yes.
Okay. Tell me about the retaliatory termination that's alleged in paragraph 6 over the last 12 months.
After I complained to him, we have an auto renewing lease that's in the lease, okay? After I complained to him about the snow, and I said, well, all right, I don't want to make you angry again.
No.
I'm trying to explain myself,
No,
but
yeah, I've asked you to
I'm
explain.
on to, you know, okay, so.
I asked you to explain the retaliatory termination. So in order to do that, you have to tell me what happened in the past in order to get to the retaliatory
So
termination.
what happened was when I got stuck in the snow, I contacted Linda.
And that is who?
Linda is the individual he uses that he said was with Northern Michigan Properties. Okay. And I said to her that, you know, that I needed repairs and whatnot. And he just was very angry about the whole thing. I'm trying to find, now these are all jumbled up, but basically, he sent me a letter after that because he was angry and he said, and I've been in perfect compliance with my rent all the way up until the point where after I got stuck and had to pull the wrecker out, and he basically told me not to contact me ever again. I don't know what landlord does that. I had that actual text, but I have to find it through the ones. But basically, he sent me this email saying that he's no longer going to renew the current lease based on the new management has decided. Can I read this or is that? The new management has decided to go another way. We feel it would be best interest in yours to move another place to suit yourself, to give your son more space. You have mentioned on several occasions that you don't like the situation of the property and voice your strong opinions about what you like or feel about us as property manager's landlord. We wanted to give you courtesy of informing you more 6 days ahead of time and get your affairs in order. So the bottom line is, you know, he's basically doing this because he's angry about this other stuff. I mean, we always, before this situation happened, we always paid our rent on time, but it just got to the point where, you know, he literally tells me not to contact him, you know, with the snow.
Does he say that he is going to terminate your tenancy or he's not going to renew your lease?
He says he intends not to renew it,
Okay.
but it's automatically, you know, it automatically renews. I mean, normally he would, but.
I just want to make sure we're dealing.
I'm trying to get to something else, so Your Honor, now this is all jumbled up ahead, yeah. So when I complained about the snow, he sent me, this is very important. Right after I served him, he sent me a letter basically denying everything, including the smoke detectors, including everything. And when he did that, you know, none of that is true. For example, he denies knowledge that that he has the no knowledge of the snow denied. Okay, that's not true at all because I sent the pictures and the text to Linda on a Saturday, the 15th. On February 16th, he contacted me on a Sunday and he told me not to contact him anymore and said this, and I quote, and this is after he said she was basically a management agency. Do not contact Linda anymore. She's a part-time secretary. Stop harassing her. We have a management company that handles everything now. They have a new set of rules for you. We put this in place to deal with your complaining, gossiping, boundary pushing, and excessive behavior. Do not contact us. We have nothing to do with you any longer. Thank God. They will be contacting you Monday and you will get a text line you can use only for emergencies. That's it. If you get stuck driving in the snow with your lowrider you can't handle, grab a shovel and wait till a plow gets there. It's not an emergency. We have multiple people watching your snow. Your false accusations and abuse of our system will not be tolerated. Goodbye for good. So after that, I wasn't sure what to do at that point. I mean, I have no point of contact, okay? And by the way, in that situation, this woman who is the new property agency, which I looked into, you're required to actually have a license to be a management agent. And that's another thing I didn't get a chance to bring up about that I was not even given proper service, okay? And she sent me a text 17 days later, okay? He told me the next day she was gonna be contacting me Monday. And it wasn't about the issues with the property. It wasn't about my legitimate complaints as a tenant. It was to collect rent. And it is as follows, if I can read it, Your Honor. Or
Does it have anything to do with retaliation, termination? That was the question I asked 10 minutes ago.
does it have anything to do with what? The retaliation?
Yeah, so my question was, what evidence do you have that the termination is in regards to, is retaliatory?
Well, I just gave you evidence, but
What I'm asking is what you have that you want to read to me, does it have anything to show that the termination is in regards, is
no,
in retaliation?
it's not about, it's merely her making contact, trying to collect rent.
Okay. Anything else about the retaliation for termination?
I have another thing, but like I said, you know, I haven't been able to pull that out on my phone yet, okay?
Okay. Then moving on to paragraph 7, that the landlord did in the last 12 months engage in stalking, repeated and continuous harassment of the tenants. Joseph Scott Newmeyer and Shane Scott Newmeyer in willful manner harassment that caused experience of intimidation, fear, or even terror. What do you have for that?
He threatened me physically. I was in full compliance at the time, and he said, and I quote, "I'm gonna come up and beat your ass." But out of the blue, and mind you, I was in complete compliance at the time, rent paid in full. He sent a text to me, which I have here. I'm just trying to find the other side of it. Yeah, okay, this is it. Now I'm in full compliance with rent, doing my thing. Okay, well, we haven't spoken in a while. I'm wondering why you have an issue with me. If there's a problem with current situation or if you have an issue, it's best to share with me and not other people. It seems we go way too long without you start talking, blame me things. I act like a responsible situation. I'm tired of hearing about how you think I'm the reason your life isn't, and it should be blaming me for things. I've tried to be straight up with you. I'm tired of your negativity. I know you're going to play it off like I don't know where, like you don't know where this is coming from and act like this way out of the blue. It's not your fault. You're not happy with your life or whatever. Stop by rubbing my name into the dirt. Keep your opinions to yourself, please. I don't appreciate it. Quit disrespecting me. You don't need to respond to that part. I'm not going to listen to your defense. This part you do need to respond to. Stop parking your car between 2 deck posts. Please don't make me ask twice. Park like everybody else does. Put the Wi-Fi booster back in the stairwell where it was. I can address all that, by the way. That's not correct. Unless it wasn't moved by you. But I'm pretty sure it's in Shane's apartment. Yes or no is fine, but last I knew that's where it was. No one else gets a signal. The internet just isn't for you. I've just tried to be nice and I'm sick of people taking advantage of me. Everything is getting turned over to a management company this fall and we'll see how they handle things. Rent gets inflated. It's called raised. It's called inflation. Bills go up, insurance, tax, internet, consumer, electric. Eventually it's going in tenant's name and you'll see how cheap things have actually been. My advice is say you're grateful because the way you look at things is garbage sometimes. I'm not your scapegoat. The people you talk shit about me, tell me about it, and I just don't throw them under the bus. I'm definitely not putting up with it. If I hear anything from you, I'm taking action. If I find out you're trying to sabotage me or make things worse, I'm going to do something about it. I want peace, but if you can't leave well enough alone, You can't leave loved enough alone. Let me know about the internet right away. The rest I don't care to hear about. The days what I says and you're too busy to talk, so I texted it. I'm not getting into a bunch of BS this weekend. We don't need the stress. That was right, what happened there. And then
When was that?
that was August 10th.
Of 24?
And that's when he referred
Of
me, by the way, to
2024?
Linda. Okay, Linda at,
Of 2024?
yes.
Is there any more of those messages?
It's what I have with me here today. I do have a ton more documentation, but it's all I could get together today, so.
So how did that cause you, because you can't speak for Shane, how did that cause you to feel harassed, threatened, intimidated?
How?
Yeah,
Because I'm living under a microscope. He threatened to kick my ass, and the bottom line is that I'm living in fear in this place. I shouldn't have to live in fear. I believe I have rights to enjoyment of tenancy. I was at this time, by the way, and I have documented receipts. I paid like clockwork, did everything I was supposed to do, complied as a tenant. And from what I've read, tenants have rights not only to enjoyment, but that harassing a tenant and threatening a tenant is extremely illegal in regards to landlord tenancy law.
so, but you didn't allege anything under the landlord tenant law, you alleged it under the criminal code. So there's very specific requirements for the criminal code, and that's why I asked you how that made you feel threatened, intimidated, harassed, or in fear of, looks like terror.
Yeah, I was looking over my shoulder all the time.
And what other, because the criminal code has specific elements in regard to that, what other evidence do you have in that regard?
Criminal code has to be, well, okay, I wasn't aware of this, but the bottom line is that I was just trying to point the absolute fact that he is harassing us while we're complying as tenants.
And give me some background as to when you would have received that message. What was happening about that time?
Nothing really.
Just out of the blue, you got the message?
I got it in August and I was surprised by it. I think he's had a problem with me talking. I mean, I do have a right, me and his neighbors speak to each other. And by the way, because I was the manager, everybody knocks on my door. The fuses blow all the time. Whenever new tenants move in, guess who they knock on? My door to fix it. To this day, I still have a key to the basement. And guess who's the one that flips off all the fuses? We are. To this day, me and my son take out the garbage for all units in that place because that's what we're doing prior as managers. When things fell apart a year ago and he just decided for some reason that he didn't like whatever, something about us, he basically made it a situation where, we were a target. And the simple fact is that, I'm not doing anything wrong here and I'm in compliance and he's calling me up and threatening me via text for no reason, for nothing.
Did he call you up or did he text
He
you?
texted this.
Okay.
Many times before what he would do. He's very clever about it. He says, I'm not bringing up the things he said to me on the phone because I can't prove it. So that would be pointless. But there have been many threats on the phone. And that's the point where you always see, I have text, more of them I can pull up. He's always trying to get me on the phone because he can say what he says and then it won't be documented. So what I did is I quit doing that. And I hoped that somehow he would send me text that would at least give me evidence that I could work with, where I could try to make this, because, listen, I wanted to be out of here for a long time. The problem is, it's money, it's finances. We're saving up, we're trying to get out of there. I tried to work it out with him. I even sent him a text, which I have a copy of here, telling him I wanted, that I would be willing to do a settlement agreement, but it's very simple. He has the power, I don't, okay? He knows without a landlord reference, I'll never be able to get another place, and he's out for blood. He wants to hurt us. That's a simple fact. And, I'm just trying to survive here, Your Honor. And the simple fact is that we've been in perfect compliance. I have receipts right here up until that point with that whole snow thing. And you told me to get a shovel. I couldn't drive my son to work. We paid like clockwork. We were completely compliant tenants. We did nothing wrong, nothing. And
But we're not here for that today. So what we're here for today is for you to prove that there's enough of a question to move your counterclaim forward.
I hope there is. I mean, this is a learning experience for me. I have legal experience, but the bottom line is that I think if I get this, I know if I get this in front of a jury, they're gonna recognize the fact that, you know, this is a serious issue for compliant tenants.
So how did you arrive at the 6 months rent or $4,500 for that allegation?
Pain and suffering, basically, you know, I mean, the bottom line is, it's the same as,
And what did you use to value your pain and suffering?
sleepless nights, my son and I having zero enjoyment of tenancy, 6 months. Your Honor, with all due respect, I haven't enjoyed this tenancy for the entire 12 months, okay? I mean, we're under a microscope, you know, constantly under threat. I mean, there's other things he does that I can't prove, but you know, the bottom line is that I have proof of all this. And I'm just someone who's trying to survive on behalf of me and my son to save up enough money and leave, you know, but now, of course, even being compliant, we're not gonna, you know, he's definitely not gonna give me a reference, so you understand where that puts us. And we've done nothing, I mean, I'm telling you, we've been totally compliant, Your Honor, the whole time. And still,
In regards to the $4,500 for the retaliatory termination for 6 months, how did you come up with that?
well, you know, a renewal of lease, my son lives right up the street. Okay, this is again, the whole destruction, destroy them thing, basically, where what he's trying to do is, he knows we got an ideal situation where we can pay the rent, but because he doesn't want us here anymore, he's not gonna let the lease renew. He knows we can't get a reference, so he's basically gonna make us a situation where really the chance of us being homeless is extremely likely now, and he knows this. Okay, he absolutely knows this.
So in order to present the case for the jury and the jury to be able to determine what should be awarded for monetary value, you have to be able to prove to the jury that you are entitled to these monies that you're requesting. And so in order to do that, you have to have a basis in which to begin that with.
Well, I've been trying to find an attorney, Your Honor, and I'm very close with that. I have 2 people I've talked to. The problem is what I've noticed, even, and I thank you for the period of time before, is there's a lot of attorneys now that aren't taking, for whatever reason, landlord tenancy law. And I originally went to the first place that you guys referred me to, Free Michigan Legal Help. I got an attorney. I sent him all the information. He did say I had a case, but he said his docket was too full, and he sent me a small amount of advice. And he told me that, you know, that I should probably pursue somebody, but he couldn't do it at this time. And I actually have those. They're not here today, but I could actually submit those. So I really believe I can win this case.
That's not admissible. That's not admissible evidence, so the court can't consider that. One question I do have, because based on I think it was a text message you read, how many apartments do you occupy?
We occupy 1.
Okay, unit 3 or apartment 3.
Yeah, we have also partial possession, that is, of the basement where, you know, because like I said, we only have 15 amps fuses. Everybody that moves in, they always blow a fuse because they're if you run the microwave and a stove, boom, boom. So, you know, what I do as a courtesy is I flip over, they bang on my door if that happens, or if, you know, they need help with other stuff, I try to help them out. I've done that for years. I did that back when we managed the place too, same thing. So that's just kind of continued on, you know. After I gave him possession of the garage, you know, he agreed to let us move some stuff down there, and then I agreed to flip over breakers. The garbage is something we do just as a courtesy, but yeah, that's how that happened.
Okay. All right. Anything else regarding your claims?
No, sir. Not at this time.
Mr. Shane Newmeyer, I know you're part of this. You signed the counterclaim. Do you have anything else other than what I assume your father has put on the record today?
Yes, nothing to add, Your Honor.
All right. Mr. Story, your turn. So I want to address step by step here. So in regards to these smoke detectors, what can you tell me about that?
The lease was given early. Previous to that, we had tried this once before. I let it be known that for lack of a better word, I had pity for Shane because he's a nice kid. I think I've had contact with him once because I went down to Cabernet. And so we tried this a year previous. There's nothing in question that this has been a handful. And so I took it upon myself and made the decision to go ahead and do another lease, and plenty of evidence there that he was compliant and happy that he wasn't getting evicted.
Was there a prior lease?
Well, we presented a lease and he said he was gonna take us to court, and we went through all this again.
Okay. So there was the lease we were dealing with here is the first written lease we have. Or the only written lease that we have.
I believe so. I have not had a lot of time to prepare or know what the questions were gonna be, because as you can see, this gets very overwhelming.
So
I just got the counterclaim.
they're alleging that between June of last year and May of this year, their smoke detectors were not working. Were you aware of that?
No, the counterclaim was the first time that it was brought to my attention, and there was a signed lease that said, you know, that, I mean, you want me to read number 16?
I'm aware of what the lease
Okay.
says. That's why I brought it to the attention, but
Thank
it's also kind of confusing because it says that the smoke detectors are working. The tenant is to replace the batteries or notify the landlord immediately or otherwise make it operable. But yet the tenant agrees to keep it in operating condition and not disconnect the battery. So I'll be honest, from where the court sits, I think there's some ambiguity as to who's actually responsible for the maintenance of the smoke detectors. I think there's no question that they either had an obligation to either replace the battery in it or to contact you and not let you know that it wasn't working.
Correct, that's the understanding.
Then in regards to the, I'm going to jump ahead to the first paragraph 5, regarding the broken air conditioners. And I did see that the lease stated that an air conditioner or a window unit was included in the lease. Back in May of last year, were there some issues with the air conditioner?
Yeah, he said that it wasn't working properly or strong enough.
Okay. And did you take any steps to rectify that?
Yes.
What did you do?
I contacted my manager. She went to Habitat, grabbed one that she could find quick that we knew would fit. We brought it to him. I didn't test it. I wasn't there. He said he didn't like it or it wasn't, you know, good enough. It was working and Habitat said they tested it. It was a cheaper unit, but I was looking for a quick response to that. And I provided another.
And these are window units, correct?
Yes, sir.
Okay. And who, do the window units stay in year round?
Yes,
They're in the window year round?
yes.
Okay. So they-
Unless the tenants decide to pull them or cover them up.
Okay.
I would like to know that my manager brought one. And as soon as I was told there was another one that didn't work or he wasn't satisfied with it, then we provided a nicer, newer one that, you know, that I was able to locate at another one of our properties.
Okay. And he's alleging that you engaged twice in retaliatory termination of the tenancy. I don't want to get too much into the facts of that because if I do determine there's a tribal issue, that's something that the jury will have to determine. But and it sounded like based on one of your answers before, there had been at least an attempted prior termination of the tenancy?
Yes, sir. We did not want to renew the lease due to Joe is a handful, as you can see. I mean, it's just everybody that comes across him gets overwhelmed. It's so hard to handle that. I didn't want to get into all the other reasons because I didn't think I had to. That would be, you know, creating a mountain of other issues. So.
And in the, how many times in the last 12 months did you attempt to terminate the tenancy?
We sent a letter in March to give him adequate time. I even offered him a discount. It was a nice letter. There was nothing intimidating about it.
March of this year?
I even mentioned his son.
It was March of this year?
Yes, sir.
Okay.
And I mentioned that in the letter that we could come later because I knew this was what was gonna happen. But I've shown that I do care for him and his son in the past and tried to help him. I gave him more time than needed.
March of this year, a complaint was filed alleging back rent. So are they hand in hand that the back rent is at least as you allege, the reason for the termination?
Yes, sir. As soon as he received that, then all of this started.
Was there any time prior to March in which you either, well, it says engaged in retaliatory termination. So prior to March, was there any other time that you attempted to terminate the tenancy?
The year before, we told him that we did not want to, well, I presented him with a lease.
Okay.
And that was because we wanted to basically change the initial agreements and things that he and I had going on, and stop the abuse of privileges that he had gained throughout our original agreement. He had access to the garage and different things like that. Rather than be verbal, I made sure it was legal. I presented him with a lease. He said, I'm taking you to court. I do not agree to these terms, blah, blah, blah. At the last second, me being busy and taking, pity on Shane, I said, you know what? And Joe was very cordial. I said, you know what? Let's try this again. And so he did sign this lease.
Okay.
And there's some text and verbiage there. So nothing's been brought to my attention. There's been a couple of texts and things like that, but this has all started after he received that letter and the text and an email.
And rent is due on the first day of the month?
Yes, sir.
Now, the next allegation is in paragraph 7, which is regarding the stalking allegation. And I'm not going to ask you anything about that for a couple different reasons. One is if you did make statements because he has alleged a criminal violation, it's possible that could be used against you if there were ever a complaint filed. So I'm not going to ask you about what was done in that case. And when I say a complaint, I mean a criminal complaint. The other reason is because I don't think that I, as I sit today, necessarily need to determine whether or not that's an issue that goes before the jury. And so, Mr. Story, in regard to just the counterclaims, I don't want to get into the back history. I don't want to get into the current rent that's owed or anything like that. But just in regards to the counterclaims, do you have anything to address that I haven't already asked you?
Yes, Your Honor.
Okay.
May I have a moment?
You may.
Thank you. I feel like we've pretty well covered it, but there's a few things that I could add to these if needed. I mean, the dates aren't right on some of this. There are no times or specific dates. There's just all this stuff that's been thrown at me. When I tried to take this on, it's literally impossible because there's so many texts from him, so many phone calls. I've had multiple staff members step in to try to mediate. And so because, I mean, I'm sorry, you got angry in 5 minutes. Imagine 6 years, okay? And I have tried to help this man, befriend him, everything else. So when I'm looking at something like this that I didn't get till Friday of last week, my heart rate's been up 20 beats a minute since then. My wife and my family are stressed out about it. And, it's just really, really tough to deal with. Joe, as you can see, he just continues to just put the pressure on. And that's, everyone knows that I stayed way longer than I should have and put up with way too much because I wonder at times if he's even mentally fit.
Okay, we're not going to get into that.
But as far as the retaliated, there is no proof of that as you can see. These allegations are simple notifications and doing our job to the best of our ability. I didn't bring any managers or anything into my other 24 tenants until dealing with this, so.
All right.
The air conditioners were provided. He didn't like the first one, so we brought another. You know, if he says jump, he wants us to say how high and show up, you know, tomorrow. And he thinks that if he makes a law, just that's Joe's law. You know, we show up, we bring another air conditioner, a nice unit, and he's angry because he decided to install it because it wasn't, you know, put in enough time that he sees fit. So there's just all kinds of holes in this. I don't think it holds water, and it's a waste of time, in my opinion. But that's all, Your Honor.
Okay. Measures Newmeyer, do either of you remember receiving the 7-day notice to quit? In this case, giving you 7 days in which to pay the $750?
Yes, I did.
Do you remember when you received that
Yes, I did.
roughly? Okay,
I have it right here.
okay.
I mean, they're not correct. I mean, I didn't get proper proof of service, but yeah, it's,
What do you mean by that?
well, you're required by law to get proper proof of service, meaning that, you know, basically, these do not match, the one filed with the court and this one. And by the way, first one, we're supposed to get, my service is supposed to be exactly the same as the service that is filed with the court. And this is like completely different in the sense that landlord says Ryan Story, Evergreen Property Management, late fees 850, 800 rent, 50 late fees. The one filed with the court says Ryan Story and no Evergreen Property Management at 750. So
Can I see your copy of that?
sure.
You can give it to the bailiff.
Oh, okay, thank you.
Okay, sorry.
Yes, please.
May I say something, Your Honor?
Hold on. I'll get back to you, but hold on.
I disagree with what he's claiming.
Well, that'll be for me to determine. So
Yeah,
let me take a look at those.
one just puts in parentheses, our property management team that we've been putting together to deal with this. States my name on both.
So I'll place on the record that it appears that the original demand for possession for non-payment of rent that the defendants received, or at least Joseph Newmeyer received, does not have Shane listed on it. Shows the landlord, landlady is Ryan Story, in parentheses, Evergreen Property Management, says that you owe $800, $50 is late fees. You must pay within 7 days. It is signed March 13th, 2025 by Cheryl A. Howe or Howie, manager, and then lists an address. The photocopy that he has presented to the court, which matches the one in the court file, shows that it was served to both Joseph S. Newmeyer and Shane Newmeyer. The landlord is Ryan Story. The amount owed is $750. The address says same as above. On the original, it shows as above. This is dated March 27th, 25 by the same Cheryl, marked as manager, but certifies that they were served a copy of it on Joseph Newmeyer on March 13th of 2025 at 8 p.m. Give those back to me. Mr. Newmeyer, I know you had something else you wanted to say.
Well, and this is what I was actually going to say in the original first hearing, okay, is that under MCR 4-201B1 and C requires the attachment of the same DFP and must show how and when it was served for us getting proper demand possession, a prerequisite to filing a complaint and then summons. As you already know, I don't need to repeat this part. But furthermore, the landlord approached me with a different management company before, that was Northern Michigan Rentals. I was suspicious, so I checked with the Michigan Bureau of Licensing. Sherlock Howe is not licensed with the state. There is no record of evergreen property management in the state of Michigan. Property managers are required to be licensed in the state of Michigan under Article 25 to operate property management. I filed a complaint on 4/8/2025 in this matter, number 25-002467. And I believe that alone is a grounds for a dismissal.
Mr. Shane Newmeyer, did you receive, you personally, a demand for possession of rent, 7-day notice?
No, Your Honor.
Mr. Story, any response to that regarding the 7-day notice?
I have not had time to look this over. Like I said, I got the counterclaim on Friday. My manager got it a little sooner. If there's something that is being taken up against me, I'd like to see these original copies and have time to examine them and discuss it with my manager.
This is what I'm going to do. Newmeyer's, it's alleged that as of March 27, 2025, you were behind rent $750. Have you been paying rent into an escrow account?
I have a bank account proving we have the money, but I don't
That's
have.
not the question. Do you have a
No.
separate account
No,
set up
I do
in
not.
order to do that? This is what I'm going to do, because the court finds that there is some deficiency in the pleadings in this case, and which is evidenced by me questioning the receipt of the 7-day notice to quit, because it's clear the dates don't match up. And then when I received the copy provided by Mr. Newmeyer, it shows that clearly, it certainly appears that there were 2 7-day notices provided, one sent to Joseph Newmeyer and one provided for the court file, which do not match. Additionally, I find that there was not a 7-day notice filed for Shane Newmeyer. So therefore, I don't believe the eviction could proceed against Shane Newmeyer. I also find that the complaint is deficient in that count number 3 of the complaint fails, which is mandatory pursuant to the court rule, fails to say who's entitled to possession of the property. So this is what I'm going to do. I am going to adjourn us yet another time, but I'm going to put an escrow order in place. Mr. Mezzers Newmeyer, I'm going to require that you catch up your rent. So I believe that would be March, April, and now we're into May, that you pay that $750 to the court. The court will set up an escrow account for us to maintain. If this case runs longer than past the 1st of each month, you will be required to pay your monthly rental amount into the court's escrow account. Any action taken by this court, because I know we're running up onto the time in which the lease will automatically extend, any action taken by this court will not prohibit the lease from being terminated. What I mean by that is, if we go past June, the court will stop the automatic renewal because we're in proceedings regarding that. So when we reach June, the lease won't automatically renew. But if you're still in the residence, you'll be required to continue to pay that $750. I'm going to give the plaintiff I'm going to order the plaintiff refile a correct 7-day notice to quit. That must be state the correct rent amount and must be provided to both parties. That must be filed with the court when served. And once the 7-day notice runs, I'm going to allow a week for the defendant, I'm sorry, for the plaintiff to correct the pleadings in the complaint. And correct the default in the complaint for the defect. I'm also going to order that discovery take place in this case. So, Mr. Newmeyer, that means that anything, any documentation, photograph, text messages that you're going to rely on to prove your counterclaims, you must provide that to Mr. Story. And I want that to happen by June 1st. Same way with you, Mr. Story. If you plan on presenting any documentation, photographs, anything like that, you need to provide that to the defendants as well.
I have a question, Your Honor.
Yes.
This is a lot. So am I able to get this in writing so I can meet all of your demands?
The court will enter an order to that effect. Yes.
I'm about resolution. I'm a very busy person. I'm a full-time dad of 2 9-year-olds. Okay. Time is money, stress, okay?
I completely
I
understand.
would much rather take thousands of dollars in losses, figure out a conditional release, figure a number that's fair, save your time, save my time, save her time, save my lawyer's time, save his public defendant's time, and get this done, because in my opinion, it's gonna continue to overwhelm the court. He has all the time in the world, so I
So
also,
are you asking for the court to send it to mediation?
I would like, in the interim, to have my office or my attorney put together a conditional release. And I would strongly urge, Joseph and Shane to take it seriously, because this is the last time that I'm gonna show any leniency. And I also want it to be known, if I have to go further with this, I am going to bring my attorney into this, and I am gonna bring criminal charges up against him.
So there is nothing that prohibits the parties from trying to resolve the case in between time. So you guys are free to try to work out a resolution. But in the meantime, I need to keep the case going.
Understood.
And I also need to protect both of your rights, and which is one of the reasons why I'm ordering the escrow account, is because I want to make sure that rent is continuing to be paid. So no matter how I determine, if I determine back rent is owed, you can be cut a check for that, and you won't have to do an action to try to collect. Or if I find in the opposite way, or actually if the jury finds in the opposite way, then the money gets cut back to you. So I do find, for purposes of why we were here today, that in regards to the snow removal, I do find that that is not an issue that will go before the jury. I find there is no basis for that issue. When it comes to the smoke detectors, I will allow that to be tried by a jury. While I do find that the contract is somewhat ambiguous as to who's truly responsible for the replacement of the smoke detectors, I will allow that to go to jury. In regards to the air conditioner, I find that the the plaintiff counter defendant made attempts to replace the broken air conditioners. While there might have been some discomfort involved, I don't find that that is an issue that should be tried before the jury. I do find, however, that there is a triable fact for the question that should be presented to the jury as to whether or not termination is in retaliation, or if the defendant engaged in stalking, if the plaintiff engaged in stalking behavior. So if we do make it to a jury trial, the plaintiff's claim will go before the jury. Allegation number 3 in the counterclaim will go before the jury. Allegation number 6 will go before the jury, and allegation number 7 goes before the jury. However, Mr. Measures-Newmeyer, you will be required to show and somehow try to prove to the jury how you are entitled to those values that you're asking for. There are certain things that have to be shown, and I can't tell you what that is.
I understand, sir.
So, what did I say, June 1st for discovery? we will reset this for what I'm going to consider as a pretrial. Some point in early June. I don't have that date yet. I'll have to sit down with my staff and see if we can find a date. Because I have a feeling we might need to hold this on a special day, not our normal date. So we will work that out. You'll get notice of that. In the meantime, and then once we reach that pretrial, we'll find out if there's a resolution or if we're headed to jury trial. So the trial that was tentatively scheduled for May 16th is adjourned because I don't find, well, I want to keep the case moving. I don't think either party is ready for trial. We'll be back here at some point in early June to see where we stand. Mr. Story, question?
I already reached out to Joe about the smoke detectors.
Mhm.
This is the second time that my manager has attempted to serve an inspection and see these things. There's been no contact whatsoever except when she,
So that's all stuff you get, he gets to present his evidence regarding the smoke detectors and you'll get to present.
what
your
about fire
evidence.
hazards and entering in case of an emergency? He's saying that they're not operable or they're not there. I've already reached out to help him with his discomfort and he denies
So-
me any access or communication.
Mr. Newmeyer, is that true? Let me ask you the question. Are you denying him access to fix the
Never,
smoke
ever
detectors?
have I denied him access. And furthermore, he did not ask for an inspection. This woman never asked for an inspection at all. I've never communicated with her directly.
Okay,
except these
first of all, I'm gonna request that we stop referring to her as this woman. That
Okay,
is so
sorry.
derogatory.
Sorry, I didn't mean it that way. I'm just saying.
So my next question is, I assume you will have no issue with the smoke detectors being fixed.
Absolutely not.
Mr. Story, do you have an idea as to when you would be able to get somebody in there to replace the smoke
Well, yeah,
detectors?
and he's lying after taking oath.
Okay.
I mean, how is that even
That-
allowed? I've got proof right here. We already asked him in an email, in a text, he will not.
Mr.
respond.
Story, my question
Yes,
is,
sir.
how long will it take you to get somebody in to get smoke detectors replaced?
That all depends on, I mean, you know, we can get that done right away, but I have to inspect it, see if they're hardwired or battery ones. And
I can help with that.
I like to take care of that stuff right away as soon as I can. If you want to give me 10 days to have some leeway, or if we can't catch Joe home and somehow he, you know,
Well, what I would like to do is enter an order saying that the smoke, given a date that the smoke detectors, that you will have access to the apartment to have the smoke detectors replaced. And at that point, you can make a determination as to whether or not they're just batteries or hardwired. I'll leave my 2 cents out of it. And whether that takes you an hour that day to do it, or if it takes you 5 hours to get the smoke detectors. I'll give you the full day to do it, but I want a date certain in which this is going to happen.
there's one other request that I have, and I appreciate your patience, sir. He's accused me multiple times of being a felon, assaulting a police officer. I don't know what kind of information or stalking that he's doing. That is incorrect. I do not appreciate him sabotaging me to my and it's a huge distraction, but it's also, you know, very offensive. He's wrong.
I
He already mentioned that in the email when we requested this.
I have no control over that. That's a
Okay.
different court. I have no jurisdiction over that. What day do you think you could have somebody in to do the smoke detectors?
I'll call my contractors and it all depends on communication, but if you want to give me 10 days, I'm sure we can get it done in the next couple of days as long as communication, but he has to communicate, you know, I can.
Well, that's why I want to set a date and time in which you can just enter the unit to fix it.
Can I call the courts tomorrow after I have some time to talk to?
I'm gonna do this. I'm gonna order that at 9 o'clock on May 15th. You will have access to the apartment. This is advance notice of that,
9 a.m.
9 a.m. And you have as much time that day as needed to fix the smoke detectors.
May 15th, sir.
May 15th, 9 a.m. All right, briefly, anything else before I adjourn?
Yes, sir.
Yes.
I can tell you for sure that I certainly never didn't cooperate with the inspections, and I will absolutely cooperate with this one here.
I know you will because it's a court order.
Okay,
So, and whether you cooperate or not, that's not for me to determine today. That'll be for the jury to determine. Okay?
yes, sir.
One last thing.
Yes.
There's no phone number for him.
Do you have a
There was-
phone number, Mr. Newmeyer?
Shane.
Shane?
All that's on there for contact is Joe's email. So if I'm to contact both of them and show proof of all of this in court and everything else, it's really between me and Joe.
Well, I was gonna say,
He wants to provide a phone
Clearly,
number.
Mr. Joseph Newmeyer is the one running the show here. And they both have the same mailing address, it appears. So when you exchange discovery back and forth, you can send it to that address. And I'm going to appoint Joseph Newmeyer as the contact person.
Perfect, thank you. Appreciate it.
One more go around. Mr. Story, anything else?
No, Your Honor.
Mr. Mezzers Newmeyer, anything else?
That's fine.
Okay, we are adjourned. Probably early next week, you'll be receiving a copy of my written order.
Thank you.
You can go back, well, no, we'll mail you your notices the next court date.
Thank you, Your Honor.
Yeah, I have one question real quick before I go. Should I get is the information I get at the court today, or do I wait for it in the mail?
You'll receive it in the mail.
Okay. It'll give me a timeline as far as the escrow and all that?
It will.
Okay, thank you, sir.
Thank you for watching. If you enjoy watching this content, please like and subscribe. It helps new channels like this one gain exposure. There is a lot more good court to come, so if you like what you saw, tell your friends. If you didn't, tell me, and let me know what you'd like to see and how I can improve. Thanks.